Jeremy Gauntlet appeared for the applicants, who included the independent presidential candidate Dr. Panduleni Itula as first applicant and 5 opposition party presidential candidates in the just concluded elections. Senior counsellor Gauntlet had a hard time convincing Justice Sylvester Mainga that the Supreme Court and not the High Court was the correct avenue to approach in order to have the election results nullified.
He learns that the ECN is still going to use the EVMs without a paper trail.
Yes.
And that is his case here.
Yes. Yes.
Why doesn't he approach the High Court? That's my biggest problem.
Taken by a period. He goes to the correct forum to ask for, rather roughly put, but the correct remedy. It gets refused. The idea, if there's a thought to Justice Mainga that he should parallel with the prescribed electoral mechanisms, i.e. the tribunal and the appellate body above the tribunal have gone sideways into the High Court, we respectfully submit that that would be contrary to law. He would rightly be thrown out by a duty judge in the High Court by saying, "Excuse me, is this about the election?" "Yes, it is." "Are you asking me for an order relating to the use of machines in the election?" "Yes, I am." "Why are you here? Is there not an electoral tribunal?" So, with respect, he was in the right place.
Senior counsel William Mokari appeared for the respondents, including the Minister of Urban and Rural Development, the Electoral Commission of Namibia, and the chairperson of the commission, among others. He explained to the court that the Namibian constitution provides for various courts with specific responsibilities, objecting to the fact that the applicants brought their case to the Supreme Court.
The mere fact that the applicants say that our ultimate objective is to upset the outcome of the elections is of no moment, it's neither here nor there. The relief, as prayed for, is a standalone relief which seeks to declare invalid and unconstitutional that determination. So we submit that this court is not the right court jurisdictionally to adjudicate this matter as a court of first instance and final recourse.
However, Justice Baetse Nkabende put it to Mokari that the case is of such national magnitude that the court cannot just close its doors on the applicants.
My question to you against that backdrop, will it be in the interest of justice or even the public interest, if you follow agricultural union, to unsuit the applicants?
Yes, of course, one will have
public interest, interest of justice, the very important historically denied right, not only here, but in South Africa as well. And given the jurisprudence that we know, will it be appropriate in all those circumstances to unsuit a party? Interest of justice, public interest, democratic principles, issues of governance, all those issues which seem to me very important to vindicate the rights of the people of Namibia. Can we simply close the door of the court to them?
Justice Dave Smuts also had questions for Mokari concerning when the respondents expected the applicants to bring their challenge to court, given they had only learned on the 24th of October that EVMs would be used with a voter variable paper trail. The justice also had an issue with the conduct of the ECN. The justice's interjections were made during the party's initial submissions to the challenge.
Discretionary power that